Indemnity is probably the most important, although when you look at the Texas legislative landscape and modern risk management practices in Texas and a lot of other cities, we're finding that indemnity obligations are harder and harder to enforce. For example, every indemnity agreement in Texas, it has to be in writing. It has to meet the express negligence test. It has to expressly state that you are agreeing to indemnify someone else for their own negligence. If it doesn't say, I am indemnifying you for your own negligence, then it's not effective. It cannot be enforced. Additionally, agreements have to meet the conspicuousness requirements of the UCC, which mean it has to be in bold letters, it has to be visible on the page, it has to be offset with either a different type, sometimes a different color. So the idea is that people should not inadvertently enter into these agreements. It should be obvious when they look at the contract that this is a provision that requires their attention. It has to explicitly state that it is in fact indemnity for someone else's negligence. Now, there are statutes that exist now. The Oilfield Anti-Indemnity Act, for example, provides that you cannot require, in the contracts that are subject to that act, you cannot require a party to indemnify you unless you agree to reciprocal indemnity and that that the indemnity goes both ways. So if you're used to contracting with folks having a one-sided indemnity where you require them to indemnify you, it simply may not be enforceable in the context of oil and gas. Now, that statute does not affect additional insurance. So you may require someone to make you an additional insured under those policies. The Construction Anti-Indemnity Act is another relatively new piece of Texas legislation. Now, the Construction Anti-Indemnity Act applies to most commercial buildings and improvements to real property. The Construction Anti-Indemnity Act precludes and prevents and in fact voids any attempt to require someone to provide indemnity or additional insurance. This is not something that people who enter into contracts that aren't construction related often look for. And many people will realize sort of at the last minute or when it's too late that the project qualifies as a construction project and therefore it applies. One of the issues that is not settled is whether or not pipelines, work on improvements to real property like backfilling where pipeline work has been done, certainly building valve stations and the rest of it. Many of those activities may fall within the scope of the Construction Anti-Indemnity Act. Now that may seem like a double whammy for folks in the oil and gas industry who deal with pipelines, because pipelines were specifically excluded from the Oilfield Anti-Indemnity Act. And I'm sure that confusion with regard to whether pipelines are or are not covered under the Construction Anti-Indemnity Act is an issue that's going to have to be resolved, but it appears right now that it's very likely that it does. And if that's the case, that's another risk-shifting issue that you've got to be able to resolve. Projects on multifamily dwellings and individual homes don't qualify. Most large commercial buildings and commercial operations will. What the legislature has done is they've tried to create an incentive for people to enter into owner-controlled insurance policies, OCIPs. An OCIP is a big wrap-up policy, and everybody that's on the work site is supposed to be part of the policy. And as a result of that, if there is a loss, if there is property damage or something along those lines, you don't have every single contractor fighting against each other to see whose insurance company is going to pay it. It's all under one policy. One of the supposed benefits is that those plans will have a mechanism set up so that the parties can decide how to resolve disputes about damage and the rest of it. So the legislature is trying to push people into those large OCIP policies, owner-controlled insurance policies. And as a result, they are taking away some of the protections that folks used to have that they could put into their contract.